and local governments for any loss of profits or potential loss of profits if said government puts in place any laws or regulations, no matter how beneficial or protective for New Zealand and New Zealand cities, that impinges on the profits of overseas corporations. Such lawsuits, and I use the term guardedly because the suits in this clause, allowed in this clause, will not be held in a court of law. They are to be settled by a trade tribunal which is not legally constituted and to which there is no appeal possible. Local and national governments are still bound to the judgments of these tribunals once the TPPA is implemented. So it's important to realize that neither the New Zealand government nor city councils can afford the multi-million-dollar settlements that are common under current agreements with the investor-state clause. Average tribunal awards under the North American NAFTA Treaty and the US-European CETA Treaty range from $1 million up to $300 million, and a case that's just been brought by the United States, by a company in the United States, a company in Canada against the United States for $15 billion, which relates to stopping of the Keystone Pipeline. So the potential awards are enormous. So therefore, the reality is that our government and this council will be forced to give in to the demands of any overseas corporation that just threatens to sue us under the investor-state provisions, because we will not be able to afford to fight one of these suits. So that effectively wipes out in measure this council's democratic processes, which is why 1,500 people gathered in the square last Saturday to bury democracy, and why about 150 people gathered out front just today. So as far as any economic gains, they've been estimated, but they fall into the margin of error of such estimations. But according to a just published story by Tufts University, the TPPA will eliminate 711,000 jobs around the 12 countries. Now that has immediate impact on councils as well. So let's look at some of the potential direct impacts on the workings of this committee. Under the Local Government Act, you must open deliberations to community input through a prescribed consultation process, which we're of course a part of right now. Under the TPPA, you will not be able to disadvantage overseas corporations when consulting. There is a major focus in the TPPA on privatization. It's embedded in the TPPA. Thus, councils will be pressured or possibly even forced into selling part of all community services like art galleries, museums, libraries, swimming pools, sports and leisure facilities under a public-private partnership or just an outright sale. When sold or entered into the public-private corporation, admission fees, of course, will be mandatory so that the corporations can make a profit. This committee bears the responsibility of economic development. Well, we've already seen the major problems that you've faced with the government taking over much of your role following the earthquakes. How much worse will it be when the international corporations usurp this committee's decisions? Venue management, same thing, forced privatization. Public participation in the democratic process. Now companies can participate, but with the TPPA, international corporations will have undue greater influence in your democratic processes. Housing, there's several issues here. Social housing. Well, what if council plans to build social housing to reduce housing costs for low-income people? But that creates a fall in rents or in house prices. International corporations could sue you for loss of profits. And building and safety codes and environmental protection codes could be challenged if they impinge on corporate profits. And imagine tenancy services having to look first to international private corporate profits. Even heritage protection and policy could be at risk. For instance, heritage protection orders on a building or trees that we already have, if a corporation wants to develop that site, they could challenge you for loss of profits. Sum it all up, the TPPA reduces sovereignty at the national level and at the local level. And it reduces the ability of future elected governments to make changes in the interest of New Zealand people. Thank you.
us here today. I'm aware of the very short time frame in which we're required to present this because time is of the essence. Today is the day of the ceremonial signing of the TPP taking place in Auckland, and with regards to time, it's nearly 2 years since I first came to the council chambers with Greg Rejdranicki, which was Thursday, April the 24th, 2014. We urged you then to inform yourselves about the TPP because of the cost to councils in all sorts of different financial and non-financial ways. On the 14th of August 2014, the council formally adopted the 12-point TPP policy solution, agreeing to the criteria of any so-called free trade agreement, which it must meet in order to meet with the council's support. There's another 1,000 signatures here that support that TPP resolution adoption. In October 2015, we asked you to use that TPP policy solution to measure the Trans-Pacific Partnership text against and to make a decision to declare Christchurch TPP free on whether the policy solution has been upheld. And there's another 1,000 signatures here supporting the TPP free Christchurch declaration. I know that your Strategy and Finance Committee has decided to wait for the LGNZ assessment, but without even engaging in any reading of the text or expert analysis, the government's own statements tell us that the TPP contravenes several of the resolutions in the policy solution straight off. It has not provided substantially increased foreign access for our agricultural markets. It has given overseas investors greater rights than domestic investors. It has expanded intellectual property rights, and it has not been negotiated with real public consultation. Writer Graham Cameron talks about the caveat in the provision for the Te Tiriti o Waitangi and suggests that the treaty exception is completely unworkable in an instance of serious dispute. He also goes on to say that the TPP will stunt our response to climate change, the most significant threat to humanity's survival, as it restricts the right of states to act in a way that will impact on corporations. Overall, the dominant corporations rely on carbon-emitting activities to survive and grow. The Aotearoa New Zealand Association of Social Workers has come out on January 26th with its opposition to the signing of the TPP, saying it is potentially a catalyst for social and human rights injustices. United Nations human rights expert Alfred de Zayas on Tuesday has called on the 12 governments not to sign and to put an end to free trade and investment agreements that conflict with human rights treaty obligations. He called for a new generation of trade agreements for the 21st century, which would incorporate human rights and development into their provisions, stressing that the TPP is based on an old model of trade agreements that is out of step with today's international human rights regime. 21st century trade prioritises regeneration rather than degradation. 21st century trade prioritises fair wages, job security and meaningful work. 21st century trade prioritises responsibility to local communities. It is honest about the effects of trade on climate change and seeks to substantially reduce those. 21st century trade recognises that outdated industries need to be put to bed as we transition into a new kind of economy that can sustain our children and get grandchildren. And it could easily do that by factoring in the costs of using or polluting the commons, allowing the invisible hand of the market to operate in a true cost environment. 21st century trade collaborates and shares, bringing a flourishing of human potential and endeavour. The TPP is not an agreement for the 21st century. Having been utterly sidelined by this government, we are seeking recourse to our only other form of political representation that will recognise the effects on local government in its own right and also stand up for its constituents. The ceremonial signing of this treaty in Auckland today is not the end of the story, but it is a significant moment moment in time in the story of this resistance to the slow takeover of nation-states by enormous stateless corporations. The Waiheke Island Community Board has declared itself and all of Hauraki Gulf a TPP-free zone. We ask that the Christchurch City Council make a similar clear, strong statement to the government that we do not mandate the signing of the TPP. We ask this committee to resolve to make this a council agenda item at its next meeting, when we will bring more background and expert analysis on the effects of local government.
Thank you very much for the presentation. We've got time for a couple of questions. Glenn, first of all.
Okay. Thank you. In terms of effects on local government, obviously procurement is a big part of what we do. Can you give us how this would roll out or not in terms of transparency, particularly under TPP?
So there are all sorts of costs for local government, including compliance and legal regulation costs. There's going to be things because of copyright, extended copyright for libraries and universities and things like that. There are going to be costs on society, which will be borne by local government as well. As far as the transparency goes, I think it's just going to be steamrolled through with legislative changes. And of course, the main thing for local government to consider is that they are also included amongst the ISDS implications. So local government can be sued as well as central government.
So according to Professor Jane Kelsey, access to the TPPA disputes resolution mechanism can deal with contractual disputes at a local level. And that would have, could rebound on contract for public services like power, water, telecoms, etc. Even if there's not a breach of the TPPA, the overseas corporations can still use the mechanism to fight a contractual arrangement, which would normally be in New Zealand's courts. Government and local body procurement will be more open to overseas tenders, and thus will create greater pressures on local businesses and employment at the local level. Government won't be able to buy Kiwi preferences to support local businesses and employment. So anything you want to do in the community could be subject, any contract could be subject to the TPPA dispute resolution, where it'll be handled outside the courts of New Zealand.
Councillor Lonsdale.
Thanks, Councillor. Today, look, I've got a 3-page document from the IOD, which is the Institute of Directors, which breaks down the TPPA agreement, and I just want to read this paragraph to you to get your view on it, because it's about investment disputes. It says it contains provisions to protect private investors' rights in members' countries so they are not violated by state action. It allows private parties to go into arbitration and seek compensation for a breach of the TPA investment obligation. MFAT says a high hurdle is unlikely to be breached if government acts in good faith for legitimate public policy reasons, follow a proper process and do not discriminate on the basis of nationality. New Zealand has a similar provision in other international agreements, including the China FTA. To date, no case of arbitration has been taken pursuant to these agreements. So that's their breakdown of investment disputes.
So if you look at the history of investment disputes, they started way back in the 40s and 50s. And it wasn't until relatively recently, in the last sort of 15 years, that it was seen to be able to be used by corporations to do underhanded kind of things against regulations that governments had decided to take in the public interest. Since that time, there has been a massive escalation in the numbers of ISDS cases, and they are covering all sorts of different things on public interest. So I think it's either willfully ignorant or quite naive to assume that we won't be sued because of, you know, just being good to corporations. The New Zealand government can't afford to be sued, so we will always be looking over our shoulders and not doing things. But what we're trying to say is that in the 21st century, with the challenges that we're going to be facing, there are definitely going to be rules where we have to come back on the things that we're allowing to happen with pollution and mining and fracking and all of those sorts of things. We cannot just assume that we won't be sued.
There's a major difference between the China Free Trade Agreement and the Trans-Pacific Partnership. The China one restricts investor state to things that are already in place.
So China's already not going to be part of this at this point? Yeah. No,
they're not, but because we've already got an FTA with them, they now get the rights of the TPP because they have this agreement that it's I can't remember the name of it, no.
You think this investment disputes paragraph is oversimplified and a little bit naive?
Yes.
So it'd be interesting to see what the LGA actually say.
But I could finish. The TPPA agreement, the China agreement is for contracts and things that are already in place. The TPPA agreement looks to things that could be in place. To give you an example, Billcom, an American company, wanted to build a quarry in Nova Scotia. It was over a city's groundwater supply. The city and the state, the city and the state turned down the application for environmental reasons. It didn't meet their environmental qualifications. Billcom sued the Canadian government for $300 million for loss of profits on something they hadn't even started. And they won. And that's where the American corporations are much more aggressive than the Chinese. The Chinese, they're subtle, they want to work with us, they want to make things work, and we're not rocking the boat, they're not rocking the boat. The Americans just get stuck in.
I will take just two further questions. If we can keep questions and answers brief, though, just in the interest of time. Vicky and then Yanni.
Thanks. Just in terms of, sorry, microphone's down here. In terms of the things that we are likely to be impacted by, I don't know that I can. In terms of the things that we are likely to be impacted by, smoke-free legislation, obviously we're involved in. We will probably at some stage want to seek priority for electric vehicles over oil vehicles. We want to take action on some agrochemicals. Obviously medicines affects all of us, potentially fracking if there was oil drilling off our shore. I'm aware that the situation in Canada and the US makes the TPP slightly less likely than it may otherwise have been. But just in terms of what you're seeking from us, because I'd like the information on the investor-state disputes so that the public have that information, rather than sort of a token thing of declaring ourselves TPPA free, which doesn't really make us TPPA free, it's kind of false advertising almost. What would be, in terms of getting that information so that people have it, so that we know the impact of those investor-state dispute settlement things on us as a community, what would be the most practical thing that we could do in response to your request, rather than the sort of symbolic label, which doesn't really make us TPPA
it's important,
free?
That symbolism. It's like having a nuclear-free Christchurch.
Just as a matter of protocol for the meeting, if we can please keep the speaking just to those seated at the table, and that's just a rule of our standing order. So if the people sitting at the table would like to respond, please.
Councillor Buck, I totally understand what you're saying, that a symbolic action is merely symbolic. In terms of what we can actually do, I mean, other than having public meetings and educating the public on things like that, there is very little. This is being taken out of our hands, and that's precisely the point to why we're here, because we don't believe that there is a mandate to do this without us.
But what would you like to ask the council to do that is perhaps difficult for general members of the public to do, that would be helpful, especially in that investor state dispute settlement area?
Well, I think that saying that the TPP is not acceptable in its current format with the ISDS, if you know that the European Parliament has absolutely refused to have ISDS in TTIP, so this is, there is a precedent for this. I think that would be a good idea, but I do think that the symbolism of TPP Free Christchurch makes a massive statement, and I think that those things are very important.
Thank you. And if we can now move on to the final question, if it can be just one question from Yanni, please.
Thank you. First off, can I thank you and for all the people that have come to support you today on what is a really important issue. I just wanted to check in terms of Christchurch, in terms of what the TPPA could mean in terms of our asset sales. So there has been in the media speculation, for example, that CityCare may be purchased by a French company. Are there any risks to us as a city having sovereignty over the asset sales if they go ahead, in terms of what the TPPA will actually mean in that regard, whether it's things like employment or labour relations or environmental laws?
So there is a city in Poland, or Poland has been sued and lost over a decision to privatise, to do asset sales, and then they reneged on that. They decided not to. The company that was lined up to buy the whatever it was, which I can't remember at the moment, has sued them and won against that country. So even just having said that you're going to do asset sales, and then if you decide not to, I mean, I note that that's already in your long-term plan, the 3-year course of asset sales.
No, actually it's not. It's capital release, and it does not imply asset sales beyond CityCare, just by the way.
Okay.
Thank you.
Relevant.
So there are effects in terms of asset sales. There will be push for private, public-private partnerships, which are often just a system of lending money from private corporations where they end up getting interest back. So, yeah, I'm not sure if I'm answering your question.
If we wanted to, if the decision was made to sell it, and we wanted to sell it to a local company, would the TPPA prevent us from being able to control the
It wouldn't prevent you, but it would open yourself to, open the council up to being sued by an international corporation because they didn't weren't accepted into the process, or it might, if there's a corporation, there's 1,608 corporations that are a party to the deal. Remember that there's only 12 countries, but there's hundreds of corporations that are party to the TPPA. 1,608 operating in New Zealand at the moment. So that if you chose a Christchurch company, for argument's sake, to sell to, someone else here would say, yeah, that impacts on our profits because we might have had a chance, or that we might be doing something similar.
Yeah, so to say that you wanted a Christchurch company to buy it would be a barrier.
It'd open you up to lawsuits.
To private companies.
I didn't mean lawsuits, but I mean TPPA suits.
Great, thank you very much. Now, I'm keen to bring this question and answer session to a close. I'm sure that there are people in the room that could quite raised all afternoon, but in the interest of time, we do need to bring the Q&A to a close. Thank you very much indeed for your presentation. It's great, regardless of what the issue is, to see the public gallery so full. So fantastic to see so many people.